Today we will discuss the most important article of fundamental rights, that is Article 32. Dr. Ambedkar called this article the heart and soul of the Constitution. What makes this article so important is that this article gives right to every citizen of India to directly approach Supreme Court if their fundamental rights are violated. So Article 32 protects our fundamental rights. If someone feels that their fundamental rights are harmed, for example, if there is forcible conversion of religion, some person is converting people forcibly from one religion to another, then the persons that are being harassed or that are forced to change their religion, they can directly move the Supreme Court under Article 32 that their freedom of religion is being violated. Article 32 gives power to Supreme Court. Supreme Court can issue writs against any authority, against any person that is violating others' fundamental rights. Similarly, High Court can also issue writs under Article 226 for the enforcement of fundamental rights. So there are 5 types of writs that High Court and Supreme Court issues for the enforcement of fundamental rights. First one is Habeas Corpus. Habeas Corpus means to produce the body. So this writ is issued by Supreme Court and High Court both. Supreme Court can issue it under the Article 32 and High Court can issue this writ under Article 226. And this writ is issued against any authority, any person who has illegally detained someone. If any authority or office or any private person has kept someone in custody or detained any person, then the relatives of that person or friends of that person can approach to Supreme Court or High Court to issue this writ, Habeas Corpus, to release that person from that unlawful detention. So that person has to immediately be produced before the Supreme Court or High Court. Second one is Mandamus, that is weak command. So this writ is issued by Supreme Court and High Court to a public authority or a government official, public servant. So this is not for private people, this is not for general public. Supreme Court and High Court issue this writ for public persons, government officials or public authorities, for compelling them to perform their duties, legal duties or public duties in a right manner and take action if they failed to do so. Third writ is Prohibition. As its name suggests, prohibition means prevention. So Supreme Court or High Court can issue this writ to lower courts or tribunals. Only to lower courts or tribunals, not for general public. Prohibition is a writ that is issued by higher courts to lower courts. Higher courts to lower courts, to stop them from exceeding their jurisdiction. Like every court, for example, district court have to decide within their district. They cannot decide the cases beyond their district. So if they do so, then the higher court can issue writ, prohibition, to stop them from acting beyond their jurisdiction. Fourth one is Certiorari. This writ is also issued by Supreme Court and High Courts to lower courts or tribunals. This is also not for general public. It is for the purpose to cancel or reject. Quash means to reject an order or judgment passed without jurisdiction. If any lower court has passed an order or judgment beyond the area of their jurisdiction, or that judgment may be in the violation of law or without their jurisdiction, then that law or judgment can be rejected by the higher courts. Quo-Warranto is a writ that means by what authority. This writ, as the name suggests, it is questioning. questioning a person. Supreme Court and High Court can question a person who is holding a public office. It is issued against a person who is holding a public office to check the legality, to check if that person is has the legal rights to claim that office. For example, if MLA has an office and their relatives are running their office, any person who is sitting in MLA's chair and claiming to that office, that will be wrong. Supreme Court can, High Court can issue a writ against that person because it is not his legal right. So in simple words, if your fundamental rights are violated, you can directly move Supreme Court under Article 32 or High Court under Article 226. Courts then issue writs to government authorities, public officers, lower courts, depending upon the situation. Situations we have already discussed in the writs. That's why Dr. B.R. Ambedkar called Article 32 the heart and soul of the Constitution. In very famous case of Nanda Bharti versus State of Kerala case, Article 32 was declared the part of the basic structure of the Constitution, because in case of Nanda Bharti case, it was ruled by Supreme Court that the any amendment in the fundamental rights or any other part of the Constitution should not damage the basic structure of the Constitution, and 32 article is a part of basic structure. Also in L. Chandrakumar versus Union of India case, judicial review under Articles 32 and 226 is a fundamental feature of the Constitution. So conclusion is Article 32 is the guarantee of enforcement of fundamental rights. It makes judiciary the protector of citizens against violation of rights by state or its authorities. So Supreme Court under Article 32 and High Court under Article 226 can issue writs to protect our fundamental rights. So guys, if you like my video and you want more such videos regarding any topic, you can comment below, and if you want notes in PDF form, I can also share the same. Please subscribe to my channel for more such videos, informative and informative lectures. Kindly subscribe to my channel. Thank you.